positive factor among qualified people will be how they feel about the person, whether they feel emotionally comfortable with that person taking care of them. Sometimes in an emergency there is no choice. You get who you're assigned to, or sometimes you go to a group or a hospital and you get who's assigned. But nonetheless, I mean, this is a very intimate process. I mean, even if it's just taking your clothes off, or if you're entrusting some important part of your life to this person, you feel the need to think at least that you trust this person and you have some relationship with them. So getting medical care involves essentially, from the patient's point of view, the creation of a very personal relationship. Certainly in situations where people get ongoing care from somebody, from a GP, from an OBGYN, whoever that is, that kind of relationship builds and increases over time. And often if people don't have that relationship, they move on to somebody else. So that's, I think, a very important background to understand about where people are coming from when the process begins. And then something bad happens. And understand that when I say something bad happens, I'm not saying that the doctor committed malpractice. I mean, that's yet to be determined. I'm just saying that there's been an unexpected outcome, a negative outcome that's troubling, worrisome, or harmful to the patient. This may be a complication of a procedure. This may be a disease that crops up that the patient thinks could have been found and treated earlier. There are just an enormous number of situations in which a problem occurs. And at that point, the health provider makes a choice. And that choice is whether to stay engaged with the patient or to disengage with the patient. And it's a sort of stay or walk away choice as the patient sees it. The choice, one choice, the walk away choice, is to be replaced by another physician or group of physicians. Now, this may be essential because the problem is not the kind of problem that the initial physician or healthcare provider can fix, but other times it may be because they've gotten advice or something that suggests that they should disengage and not be involved any longer. The other choice is to stay involved. Even if you can't be providing the care, the health provider can still continue with a relationship with the patient. Most of the people who come to a malpractice lawyer are people who are angry or disillusioned because the provider walked away. It's the single biggest driver. There are three major reasons that bring people, but this one is the one that brings people with the most sort of urgency and anger. And I should say about this that it comes because at a time when they thought they had a relationship, needed hand-holding, needed support, they felt like they were abandoned. And for these patients, that is, in their mind, a betrayal of trust. Many people are actually the victims of malpractice and do nothing about it. And in my experience, those are people who maintained a relationship with their provider and had the choice about whether to do something economically, and they could afford to ignore litigation as an option, and they choose to avoid it because they continue to have a relationship with the provider. Now, risk managers used to be the source of a lot of the problem here for doctors, which is they told them not to talk to the patient anymore and do things like that. The law has changed in North Carolina and is changing all across the country. And so most states are adopting or have adopted something like Rule 413 in North Carolina of the Rules of Evidence, which says very, very briefly, statements by a healthcare provider apologizing for an adverse outcome in medical treatment offers to undertake corrective or remedial treatments or actions, and gratuitous acts to assist affected persons shall not be admissible to prove negligence or culpable conduct by the healthcare provider. Okay, so there isn't any reason why continuing to engage with the patient will be used against the physician or healthcare provider And so that does give folks like that more options. Now, thus far, I've only been talking about the emotional response of a patient to feeling abandoned. There is a second and important reason that needs to be talked about, and that is that the injury or outcome was unexpected. That is to say, there was some element of surprise in the problem happening. A lot of times patients go into surgeries with a problem and understand that it may not be fully fixed or that there could be complications. And those patients are less likely to come see somebody. Now, let me be very clear. Sometimes the healthcare provider explains it well to the patient and the patient doesn't hear it. That happens. You know, we all have the experience of hearing what we want in something and not hearing the bad news, for example. But nonetheless, the second common element of people that are in a malpractice lawyer's office is that an unexpected bad result has occurred. The third factor is that there has been a substantial injury. And that is usually a permanent injury or death. Those are the things that really finally conclude the three most common things that I see in people in malpractice lawyers' offices. So what I should tell you is only one of those factors actually weighs in the decision of whether to take the case, and that's the substantial or permanent injury or death. Those other two factors really don't affect the lawyer's decision whether to take the case. But there are two other factors that do have a great bearing. And the first one is, how severely or substantially did the doctor depart from a recognized standard of care? And how closely connected was that departure to the substantial injury or death? And if those sound familiar to you, particularly those who have recently taken tort, we're talking about duty, breach, and proximate causation. And then when you think about the substantial injury part, we're talking about damages. So ultimately what the lawyer's deciding is, can he or she meet the elements on behalf of this patient? A lawyer that wants to make a living doing malpractice work can't ignore the elements because the court won't, and surely the defense counsel won't. And I love that Charles Holton is sitting here, who has done this kind of defense work for, I think, a huge part of your career, right? For Duke and for other people, and we've had cases with each other. But what I was going to say is that not only are these cases hugely expensive to bring, you know, I've seen cases where the lawyer will have advanced on behalf of the client between $250,000 and $500,000 for the expenses of litigation. So imagine if the lawyer loses, the client can't pay that back, and the lawyer has been compensated zero for their time. No intelligent person who had other options, and most good lawyers do have other options, would do this work unless they had meritorious cases. It wouldn't make sense. There are incompetent lawyers or inexperienced lawyers that do bring cases that I would consider unmeritorious or frivolous, but they don't do that more than once or twice because you can't make a living doing that, and those cases are normally tossed out relatively early in the process. But what I want to say is the other driver on the decision side is the people on the other side of these cases, the defense lawyers, are the best trial lawyers in North Carolina, without question, in my mind. If you're looking for the best defense lawyers in North Carolina, they are the lawyers that try and defend medical malpractice cases. So I think that uses up my time. At some point, I guess we'll answer questions or do whatever, but I'll pass now to whoever's next. Doctor?
So I want to introduce you guys to Dr. Berchuck. He serves as the director for the Division of Gynecologic Oncology here at Duke. He also conducts cancer research here. From 2007 to 2008, he was the president of the Society for Gynecologic Oncologists, and he has served as both a plaintiff's and defendant's expert witness. Thank you.
So I do have a few notes. I've never spoken in this sort of forum before, but it is a pleasure to be here. There's a secret little part of me that would love to go to law school and learn more about this. And I think that interest has been stimulated through the experiences that I've had acting as an expert witness. So I've been at Duke about 20 years and am the director of the Division of Gynecologic Oncology. We take care of women with cervical, uterine, and ovarian cancer primarily, and that typically involves a combination of surgery, chemotherapy, and radiation, so fairly toxic therapies with potential for damages for sure. As Maya mentioned, I've had experience as an expert, and my former boss, who was the head of the division when I came, really got me started on this. And it was something that he did and said was interesting, and so I sort of dipped my toe in. And I have to say that being an expert has made me a much better physician. And so not only has it been very interesting to get sort of a view into the legal world, but also I think the lessons that I've learned in reviewing cases have come back around to make me a better doctor. So I'll start off by talking a little bit about some of the experiences that I've had and how they reflect on the whole malpractice scene in general in the U.S., and then also specifically some of the things that I've learned. So the crazy thing, I think, is that most lawsuits I'm asked to look at the medical records, whether it's from a plaintiff's attorney or from a defense attorney, after I review the material in the case, I feel like the majority of them don't really have merit because just getting back to the sort of criteria that we just talked about, there's damages, but there's not necessarily a breach of the standard of care that caused those damages. And so most of the time, yes, I'm a doctor, but as an expert, you're really working for the lawyer who's employing you. So I think that one tries to be objective and not always just try to come to the defense of the physician who's being sued. I think still that objectively, most of the lawsuits that I see, at least in my area of medicine, are not really malpractice. But on the other hand, the other side of the coin is that as a practicing physician at Duke for 20 years, I've seen a lot of things happen that probably were malpractice, and most of the time, the things that happen that truly are malpractice never result in a lawsuit. And so it's sort of ironic, or it's the yin and yang of the medical legal world. Most lawsuits are without merit. Most injuries that occur that should be a lawsuit don't ever become a lawsuit. And so, again, I'm not really an expert in medical legal affairs, or I don't follow too closely the malpractice crisis and legislation. And I did hear recently that Obama's health care bill has some money for grants for states to start to look at the process and so forth. But again, it's not something that I follow very closely. But the lawsuits that I mainly see often have to do with failure to diagnose a cancer, and then when the cancer is diagnosed, it's too late. It's going to be a fatal cancer. And cervical cancer is a disease that worldwide is still one of the leading causes of cancer deaths in women. And this would be in Africa and other undeveloped areas where they don't have cervical screening with pap smears or HPV testing. In the U.S., the rate of cervical cancer deaths has dropped by over 80%. And so it's almost gotten to a point where if someone's dying of cervical cancer, it must be malpractice because this is a preventable disease. And what we have is kind of residuum of cases where most of the time the tumor tends to arise up high in the cervical canal where it's not as visible or easily diagnosed with screening. And so again, I think most of those cases are defendable because the physician didn't necessarily make a mistake because screening techniques are not perfect. They may have had normal pap smears and so forth. On the other hand, there are system errors. I think one of the big lessons I've learned is that a lot of errors, true errors that result in malpractice, are so-called system errors where there's not just a good system in the office where when someone has a pap smear that someone actually checks on it and makes sure the result goes to the patient. Things in the past certainly have at times fallen through the cracks, and someone might have a pap smear and it might be abnormal, but it just either never comes back to the doctor's office or it just gets filed in the chart and nothing's done to evaluate it, and then the patient's got cervical cancer. And one of the cases where I was a plaintiff's expert involved such a case where a young woman was dying of cervical cancer and had children, and there was certainly a settlement for the plaintiff in that case. So I think that one of the good things that's happening with computers and technology is that a lot of systems are being put in place to get around human error. This relates to not only checking labs, but an entire electronic medical record where information about a patient would be widely available to all physicians taking care of a patient. But I've seen instances like with ordering of chemotherapy drugs, like cisplatin is a very toxic drug that's used to treat ovarian cancer and a number of other types of cancer. And before the recent times, often those orders would be handwritten, and everybody I think knows how sloppy doctors' handwriting is, right? That's kind of what they make fun of us for, and there's things they make fun of lawyers for. But our handwriting, doctors, oh, your handwriting's too neat, you can't be a doctor. But I reviewed a case where a patient had gotten a 10 times higher dose of cisplatin than they were supposed to, simply because of sloppy handwriting that was misinterpreted, and there was no system within pharmacy to pick up on that error. And cisplatin, when you have too much of it, can knock out your kidneys, and so this patient was permanently going to be on dialysis, and it also can affect your hearing, and she had substantial hearing loss. So again, a legitimate injury and a win for the plaintiff. The other side of it, though, again, I'm sure you're all aware that a lot of people are cynical about lawyers and the profession of law, and it's an adversarial system. I've come to realize that as you sit in depositions, lawyers go back and forth and yell at each other. I never forget the first deposition I gave, which was about a case when I was a resident. It was the first time I was ever involved, just testifying as a fact witness, because I'd been involved in this delivery that had a bad outcome. And the lawyers were screaming at each other, but then when it was over, they were going out to lunch and were good friends. And so I think the adversary system is a good one and distills the truth, hopefully, if you have strong advocacy from both sides. And I think that although at times I've felt like, well, when I'm at a trial and I'm looking out at the jury and just thinking, how in the world are these people ever going to make sense of this technical, scientific, medical sort of stuff? But I've reviewed quite a few cases. Only 6 of them have ever come to trial. And I feel like ultimately the decision that was made by a jury of citizens was the correct decision in all cases, even on one where I agreed to go to trial and testify, but I thought they should never be bringing this as a case to trial. I thought they were going to lose, and they did lose. So somehow the jury system, despite any frailties it might have, seems to work. At least in my experience, it's kind of 6 for 6 on things that went to trial. So just a couple of other things. I think that I hadn't thought about this, but one of your comments about trust. Charles Hammond, who was the chairman of OBGYN for the first 15 or so years that I was here in the department, always stressed at our weekly conference where we would look at so-called M&M, morbidity and mortality cases where things had not gone right. He always stressed, always tell the patient when something goes wrong. Don't try to hide it, and always stick with the patient. And so I guess I've always taken that so much for granted that it didn't occur to me that maybe anything would ever be otherwise. But I've seen it pay off in some funny ways, too, where I had one patient who was having a hysterectomy that was being done through the vagina where you kind of pull everything out from below. And to make a long story short, we wound up, the resident, who was doing the case with me assisting, made a hole in the bladder, which is right, above the vagina. And we fixed the hole, and we weren't that worried about it. We figured it would probably heal okay. But the next day on rounds, the resident came in before me and said to the patient, during the surgery there was a hole in the bladder. And the patient said to the resident, well, I know Dr. Berchuck didn't do it. And the resident was like absolutely mortified because she figured, well, the patient was going to be blaming her. Before she could say anything, the patient said, I think my doctor at home made that hole in my bladder when he did the D&C before he referred you because he was awfully rough. So again, something about the doctor in Burlington, she didn't like him or something that wasn't right, and so she was very easy to blame him for anything that went wrong, but because she liked us, even though we were the ones that had done it, she was very eager to excuse us and kind of write off that we had done anything wrong. So I guess I'll just end by saying that in looking at the internet a little bit in preparation for this, I was reminded that the Institute of Medicine did a report about a decade ago called To Err is Human. And I think we're addressing a lot of the systems issues, a lot of the medical errors that are made just because of poor communication or just things that are avoidable with systems, with checklists. Like there's a bestseller out now, The Checklist Manifesto, which is written by Gawande, who also wrote a number of other books that have been bestsellers like Complications. And he just talks about how many errors can be prevented and how the quality of care can be improved by having a checklist for things, that are really required steps that can reduce infection and so forth. And, Medicare also has a program now called the PQRI program, where if you participate in this program and you choose several indicators, like making sure a woman's had her mammogram, making sure that people have had their flu shot, making sure they've had prophylactic antibiotics before surgery, if you document that and get it right on over 80% of your patients, last year you got a 2% bonus on your total Medicare payments for the year. It's 1% this year. It's shifting to a disincentive mode next year, where if you don't do it, you'll have a 1% penalty and then a 2% penalty. So physicians are going to be increasingly paid for the quality of their care. In the past, we've been incentivized to do a lot, because the more you do, the more you get paid. It's a fee-for-service business. And so I think the new move towards really incentivizing physicians to look at the quality of care that they give and to really be sure to do the things that are documented to help people and not just skip over it, either because of system issues or laziness or sloppiness. But again, the final sort of part of the phrase, to err is human, is to forgive is divine. And I don't even think that was in the title. I think just the title of the report was to err is human. But the tagline is to forgive is divine. So I think that, again, as a physician, I feel like I've learned to be a better doctor by being an expert and seeing the things that can go wrong on these cases and hopefully avoiding those mistakes, but also practicing as Dr. Hammond told us to do, and to always admit mistakes and to stick with the patient. So again, thank you for the invitation, and I look forward to the discussion.
Don't say much.
Okay. Professor Metzloff practiced with a private firm in Atlanta before coming to Duke in 1985, and he has extensive litigation experience with medical malpractice.
Okay.
I think it might be to err is human and to compensate is just, is what a lawyer might say, which is probably part of the issue. There's so many ways we can talk about malpractice, and I do want to leave some time, a lot of time for questions. In some ways, if Don represents sort of plaintiff's interests historically, and we have a doctor who's maybe thinking about sort of the medical side. I could be here talking more about the defense side, but I really have, my interest in malpractice has been on the research side. So when I first came to Duke, we had several grants from the Robert Wood Johnson Foundation and did a lot to try to promote the use of alternative dispute resolution in malpractice. And part of that we ended up studying. We looked at every case that was filed in North Carolina over a 3-year period, which is about 1,000 cases. And tried to look at procedurally how they're handled. So maybe I can just give some perspectives on malpractice and some of the issues that are today. In some ways, when I look at what's going on today, I feel like it's deja vu all over again, as Yogi Berra would say, because we're still fighting some of these battles about tort reform and what we should do and shouldn't do. And in some ways, the world isn't that much different than it was in 1985 when we were in the midst of what was then the second malpractice crisis, and then they kind of come and go. And so maybe we can talk a little bit about that. I remember if you were here last week, there was a little sign on the corner out there, and it was pointing that way, I assume, to the business school, and it said, Conference on Evidence-Based Medicine. And so there is that real world of where the medical profession is changing, and we just heard about that. How do they do things? What is the standard of care? We have to translate what they do in their world over at the hospital, which they do generally very, very well, and we all appreciate all the amazing successes that they have. I have a close person who was successfully treated for cervical cancer, so I'm very thankful to Duke for that. What is evidence-based? So, as a legal profession, we're trying to figure out how do we deal with this very dynamic world of medicine, and we take it down to a specific case of an individual plaintiff and a defendant with a jury, and we sometimes simplify and oversimplify, and I think that's why the medical profession has some problems with what we do. We're very different regimes and very different practices, and we each have our goals. that we have to try to accomplish. So when you look at malpractice, how is it like or not like other things? It's not like car accident cases. I was involved in that with my father-in-law. A case was filed and settled. We didn't even know. He said, "Whatever happened to that case?" And eventually I found out it had been settled without anybody telling us. I was not too pleased with the defense lawyers. I thought we owed that. That would never happen in medical malpractice. These are tough, litigated cases. Doctors have lots of input about the settlement decision. In many states, the insurance companies, which are doctor-owned companies, the biggest malpractice insurer in North Carolina is Physicians Medical Mutual of North Carolina, owned by doctors, and they pay in, and they, if things go well, they'll get some of their premiums back. They get to have a real input into the settlement process. And one thing, you can never,